Hi there. So I'm going to address this talk to Rowan Atkinson, the previous Archbishop of Canterbury, because he might understand this. I've actually been getting some success with some of the other groups, but not with Extinction Rebellion and Just Stop Oil so much. I got some progress with the Trudy Warner case. I've been making representations through Judicial Conduct Investigation Office to the Lady Chief Justice, and I've been having some successes. I support all campaign groups for rights to try and explain and get the rights applied properly. This might include some groups that Extinction Rebellion or Just Stop Oil might not be the greatest fans of, but it's important that the rights get properly applied, or there's no point having them. Sometimes I think Extinction Rebellion and Just Stop Oil don't actually really care about the rights, and they're not bothered. If they only cared about the environment and not about the rights, then they've got no right to act, and everything they do, they're just going to get put in prison. Now, if that's your objective, is to just break the law and get put in prison, and there's not really any defence, then you're complaining down a losing argument, because then they're only making a defence and claiming there's no rights. But there is rights, and they haven't been getting them right. So not everyone seems to know the 1688 Bill of Rights, and I don't know why that is. It's widely known. It's been heavily publicised. Some of the campaign groups just do not, I don't hear them talk about it or mention the word, the 1688 Bill of Rights, right to petition. So, but they always comment on this William Penn and William Mead case from the Old Bailey that's on the plaque, which I've got the full dialogue for that. If you read the full dialogue, and if you understand that, my copy of it, it's a tumult. It's actually an offence under the 1661 Tumultuous Petitioning Act, which has been repealed now. And when that William Penn and William Mead case was in effect, there wasn't the 1688 Bill of Rights, right to petition, but they petitioned under Magna Carta. Now, if you read the Erskine May Parliament book, The Usage of Parliament, they've got it on the website, but they don't publish all of it on the website. They just pull bits out of it, and they leave the bits out that they don't want you to know. And the first edition is the best one. That has an entire section on petitioning. And in that Erskine May book, it clearly and unequivocally, with great clarity, explains that when you're petitioning the Parliament, either Houses of Parliament or the King, which is all these political campaigns are calling for action from Parliament, right? You're under parliamentary privilege. You do it under privileges of Parliament, just like any MP, right? So you are covered by privileges of Parliament. If you want to argue how far those privileges extend to activities, that's a different argument to defending a charge. But they're not even raising these privileges. Now, in that book, Erskine May he lists the Bill of Rights, but also Magna Carta. There's only one thing in Magna Carta that you can use when you're petitioning, and that is the judgment of your peers, but not when you're being charged with an offence. Because the peers, you've got to understand the whole legal framework of bringing a case, raising a case, initiating a case to the Parliament, initiating a cause, whether it's a criminal case. If someone steals something, you call hue and cry in the 100, and then the sheriff puts out a official statement that, the crime has been committed, and everyone then has to pursue the criminals. Everyone pursues the criminals under the case. Everyone has the right to pursue, apprehend, detain, whatever, the criminals, right? And that is the case. They're pursuing a case, a criminal case. You don't have to prove beyond reasonable doubt in front of a court that someone stole something in order to pursue the case. After you've apprehended them, then they will be judged whether they're guilty or not before a court, that you have to prove beyond reasonable doubt. You don't have to prove beyond reasonable doubt that your jacket's been stolen in order to pursue it, right? Now, it's on the oath of the statement, the oath that, I swear my jacket's been stolen, that is a truth, right? And then everyone has to pursue the case, right? And they've got privileges pursuing the case to retrieve the jacket, to apprehend the criminal, right? That's on the oath. This is using the right. So in Magna Carta, when you do a petition and it is signed and under the oath of, people, and you officially declare it or address it, you're pursuing the cause, the case, and that is where the privilege comes in and the immunity to pursue it. And that is where the 1688 Bill of Rights comes in, and you're not liable to be prosecuted in a similar way to what the police aren't liable to be prosecuted in some circumstances, but it is governed by legislation. It's legislated. It can be reasoned. It can be reasoned what the police can or can't do in pursuit of crime, depending on what legislation and what they're doing, right? But they don't have Parliament privileges. When you've got Parliament privileges, it says all prosecutions against you are illegal, and that's true. And what it works out at, and I'll explain how and where it tells you this, is that it works out that you're not criminally liable under the Constitution. You're not criminally liable for your actions. Obviously, if you murder someone or something like that, it's questionable what you're doing. But this is what these courts, I guess, in a way, but they're not acknowledging that there is a privilege, and they're not even arguing whether a privilege applies or not, and they're not even saying whether it falls under it or not. They're just prosecuting it like a normal crime and making them submit a defence, which is not correct. And I've done a separate video on right recognition. What is it to recognise a right in criminal proceedings? You don't prove a right beyond reasonable doubt in front of a jury. You recognise a right into effect, which means you don't have to prove it beyond reasonable doubt. And that's a separate video that I'll put in there, because there's quite a bit to say about that and give examples. So yes, there is immunity from criminal liability in pursuit of the petitions and activities, but it says in another act which was enacted around the same time of the 1688 Bill of Rights, one that is less known. I discovered this through Professor Karen Bowie. It's called the Claim of Right, 1689. It's similar to the Bill of Rights. That act has more context and clarification for the Bill of Rights. And also, you can also find the actual dialogue from Parliament from when they were enacting the Bill of Rights. All the dialogues there, it's all around the ideology behind the Act of Indemnity and the Act of Grace, if you want to look into them, where, they're saying, they're going to give people this indemnity, basically. In the Claim of Right, it clarifies that the right to petition in the 1688 Bill of Rights, it's not just that all prosecutions are illegal. You definitely can't be put in prison. You can't be committed to prison. It's got a very specific cause in there for petitioning. And Roger Hallam has been committed to prison. And another clause in there, it does actually describe and indicate that you could be liable to civil actions. If you cause damage or harm to anyone else, you could be liable to civil actions. So, and that is actually correct and follows suit with the 1100 the 1100 Charter of Liberties and the Magna Carta privilege of peers. Peers can be judged only by their equals. But when it says in the Charter of Liberties that, you know, peers shall stand for their crimes, that's just in going about normal behaviour and conduct, not if they're actually doing this, what you call this petitioning, which is pursuing a case. They could be pursuing criminals. Another area of doubt that most people have is, were Extinction Rebellion really doing a petition? Well, Extinction Rebellion have had some petitions on their website in the past, and they do petitions from time to time. But the question is that most people ask is Roger Hallam even doing a petition to government when he's sat, you know, talking about putting signs and banners or notices over the motorway to promote Just Stop Oil and raise awareness of it? So that's what they were doing, as far as I've gathered. But we'll get into what they were planning to do in later, because I want to try and describe this first. So there, in the 1661 Tumultuous Petitioning Act, it describes, well, it's Public Act 13 under Charles I. It describes, under this umbrella of petitioning, it brings together public remonstrations and addresses to either Houses of Parliament, the Lords or the Commons, or to the King on matters of church or state or law. Well, that and people who give their oath subscribe to these remonstrations and petitions either by their hand, putting their hand to it, or by any other means, which is like a verbal agreement, a verbal contract, or maybe raising your hand or nodding like you do at an auction or something like that, you know, officially acknowledged. They do this in Parliament when they get the Speaker in, you know, they just... all the years and all the nays, and they just go by the volume of it, you know. That's the act on it, you know. So that qualifies in law, proves that the 1661 Act proves that what we're talking about when we're talking about petitioning, right? So let's go back to Just Stop Oil and Extinction Rebellion. Have they always got an active petition? Are they always remonstrating for an action from the government, from either of the Houses of Parliament? I would say yes. The thing with Extinction Rebellion is that they do have on their website, they do have, I would say it is an agreement. They say that if you want to use Extinction Rebellion logos, banners, and do actions and represent the cause, you have to agree to their principles. And they've got these, like, a list of things they're asking from the government, like they want a citizens' assembly, and that, you know, they're against, you know, any more damage to the environment and so forth. I actually don't know them all off by heart, because I'm not myself. I do like Extinction Rebellion, I do follow it, but I'm not like 100% focused on Extinction Rebellion, just like on campaign groups as a whole. So just like all campaign groups, But I am aware that they've got a website, and then they've got like a mission statement, and that they say that if you act on behalf of Extinction Rebellion, use their logos or do actions, then you only do so with the consent and agreement of that statement, which is the oath, right? And you consent to it by hand or by any other means, right? So it has got a cause. There's an official cause published to the public or a section of the public seeking resolution from either houses of Parliament, right, or the King, because that's what the point is, and raising awareness to get more public to support it by donations or helping to raise awareness or writing to MPs and so forth. So we definitely know that Roger Hallam and his party of people who were arrested for this offence, we know they're acting for a resolution from either House of Parliament, and we know that they've got a list of requests or demand. They call them demands, and we know that I've successfully acted through Judicial Conduct Investigations Office for a number of campaigners now, and their cases have either vanished from the magistrates' court or be withdrawn or no further action taken. Except Trudy Warner, I did some help. I didn't do, obviously, she's got her own help, but I did some additional help through JCOI, which I think helped towards it. But then the Attorney General raised it to the Supreme Court afterwards. I actually complained about the Attorney General as well, the previous Attorney General. So, Victoria Prentice. So, the Thomas Erskine May book, unequivocally and with absolute clarity, says that the petitioning activities fall under privileges of Parliament. And we know that you're not supposed to be put in prison. Now, you might say, well, what if you break the law or break laws of England? You know, is it only you can't be prosecuted for petitioning itself, but only for breaking laws of England? Well, it says all prosecutions are illegal. Why would you be... It protects you against prosecutions. Petitioning isn't illegal, and it wasn't illegal before the right to petition. Some people think that it means that you can't be prosecuted for doing the petition, but doing the petition was never illegal. So it can only mean over any offences that you will be prosecuted with that are illegal. I've got an explanation for that as well. Hopefully Rowan Atkinson can understand it, and that is that if he looks up the cases of Henry Burton and John Bastwick, these are research cases. These are well-known research cases for historians. John Bastwick and Henry Burton are two separate case examples from the 1640s of getting prosecuted for petitioning or remonstrating or calling for actions from government in church or state or law, and actually it's in church. So they're trying to get people to support their call for change, for example, in church, because these two men are actually prolific religious persons. In fact, I think Henry Burton very nearly became the Archbishop of Canterbury at one time, I think, but he didn't manage to because obviously his views were not aligned with the King's. Now, these John Bastwick and Henry Burton, they are prosecuted respectively in their own case in the High Court of Commission by the King. They're not prosecuted at the Hundreds Court or in the Church Court at a local level or so forth, because when they're remonstrating or doing petitioning, as we've said under Magna Carta, on their case with the support of their church congregation or following to petition the king, they can't be prosecuted because they got the consent support of their peers. The petition comes with peer judgment that you're all pursuing a cause, right? So you've got the privilege of the judgment of your peers that everything you do is required for that cause. That's the basis. What they were getting prosecuted by is the king at the top level, right? The king was still prosecuting them, right? But it's granted that, you know, for local demonstrations or protests, they couldn't be prosecuted because of Magna Carta. The judgment of their peers all signed up to the petition, which is an official oath and a declaration. They're only getting prosecuted by the king because the king thought he could do what he wants because, you know, it's to do with the fact that, you know, barons and lords are higher or separate in the king from the common people. That's why in the Charter of Liberties it says, you know, barons and lords should stand for their crimes like anyone else, rather than binding to the crown. They end up giving the Magna Carta, that's in 1100. By the time of Magna Carta, barons and lords in 1215, barons and lords can only be judged by their equals. So they're not in this peer pool judgment of at the local divisional court level with the common people, right? They've got exclusive judgment for their crimes. They can stand for their crimes. People can accuse them of crimes and they can be prosecuted, but it has to be in front of a court or of their peers, right? In obviously, you know, with the other lords and barons, only by their equals. So this is the thing. In the 100, when you are the person who raises the case, you're the person with a case, and when it's acknowledged publicly that you're doing this, and you know, with an oath that that's what you're doing, and the people sign to it consent, this is like judgment reserved, you know. Now I think that when these people were getting prosecuted at the High Court of Commission, it was like, you know, normal common people, you know, they were getting a judgment by the king or from a higher level because, you know, but they weren't getting prosecuted by their own peers, so they wouldn't stand in front of a jury, right? Because it's the Court of High Commission. They actually ended up with their ears getting cut off and put in prison for some time. And then under, I think it was was it the Long Parliament or the Short Parliament? John Pym, the Parliament that John Pym was in, who was meant to be, John Pym is still accounted for being the greatest parliamentarian. So John Pym, right, in the House of Commons, the wives of both these John Beswick and Henry Burton, on these separate occasions, which were around the same time, but two separate cases, they actually petitioned John Pym, or the House of Commons, for the release of their husbands. So the wives of Henry Burton and John Beswick were petitioning for the release of their husbands, and they actually they did get released. They passed it through Parliament to release them. Now, this is what this petition now that, you know, Just Stop Oil are calling for the release of Roger Hallam. If you try to submit that to the Petitions Committee on the Parliament website and type it in, when it's back open again, it might be open now. It wasn't open yesterday or the day before, I don't think, when I checked, because they haven't appointed the Petitions Committee properly yet under Starmer. So they'll probably reject it and say that, oh, well, they used to say, oh, you can't petition about criminal matters, which is a lie. You can. And then they started more recently, just before the end of Sunak's government, they'd started changing their tune. They'd started saying, "Oh, you'll have to see your MP about it," because they didn't want to publish it on the petition's website and have it there in text, in writing, or someone's petitioning for a criminal matter, because they didn't really want everyone to know you can do it. And the statute law that supports it all has not changed. And so the Archbishop of Canterbury I don't know if he's aware or knows or has studied the cases of John Bastwick and Henry Burton, but those cases prove that, petitioning for the release of prisoners is within the right to petition, something that you can do within the right to petition. And that was in the 1640s. I think that was just before the Civil War. In fact, it could have been something that led to the Civil War. In fact, Henry Burton getting his ears cut off when he was one of the guys who very nearly was close to becoming the Archbishop of Canterbury. This is when we end up with that. Was it Lord guy, Loud, or whatever it's called? The Archbishop of Canterbury, who was at the time of Oliver Cromwell, he got executed, unfortunately. The people aren't widely aware that there was some issues and feelings under this. The Henry Burton and John Bastwick cases are events which fueled or fed into the whole Civil War, among other matters. So that's got something to do with it, really. So that it proves you can petition for the release of prisoners, and if you've got the only law under the right to petition is that you've got the free right of subject. I am the subject, and the subject comes from me. I speak the subject. I am a subject speaking the subject. So. And you might say, well, what about, Parliament standing orders or resolutions? Well, there hasn't really been any standing orders or resolutions that could stop you petitioning about criminal matters. For example, we can look at the Courts Act 2003 and the Justices of the Peace Act 1997, which is repealed, but it's the same as what's in the 2003 Courts Act. They've got these principles set out that this is for clerks and for issues to do with justices and clerks, but it says that any pursuit of a resolution from either of the Houses of Parliament, right, will result in annulment of the matter that you're appealing against. So, if you really have been convicted or prosecuted, and you petition Parliament for a resolution, it should result in an annulment, while you're waiting for a decision, which is the exact same basis or model if you appeal from a magistrate's court to a Crown Court or a Crown Court to the High Court, right? But this is to the Parliament. You might say, well, you can't appeal to the Lords. The thing with the Roger Hallam case is that it was illegal for them to be prosecuted in the first place. They actually were under privileges, so really the prosecution's illegal. And because it's against Magna Carta, it's void. all judgments against the Great Charter are void. So Hallam's imprisonment actually is void. I've got all the statute law for this. You can check it out. So he hasn't really been prosecuted. He's been detained unlawfully. And you might say, well, we're appealing to Parliament. They took away the Appealite Jurisdiction Act, but the Appealite Jurisdiction Act was never required in the first place. Those cases of Henry Burton and John Bastwick, when their wives petitioned Parliament for the release of their husbands from prison, there wasn't an Appealite Jurisdiction Act, and there wasn't even the right to petition. So, riddle me that one. It was purely on the basis of the Magna Carta. I don't even think that the 1661 Tumultuous Petitioning Act hasn't even been invented either. But they were still meant to have this Magna Carta consent. The peers had judged that their petition was correct, and in order to be pursued, and they need to do what they needed to do to deliver it, just like a police decide they need to do what they need to do to pursue a crime, supposedly in the public interest. So I think with the petition, it's meant to be in the public interest if you're getting signatures from, the public at large or a section of the public. You can. This is what Edward Fitzgerald covers in his book Smoke and Mirrors, and it's also what William Keat on his website. William Keat is all over this. This is what William Keats appeared on Neil Oliver recently. He's appeared on Verbs, but I don't think people put it into contextual use of how this applies and what even is it and what is it for. In some of its manifestations, not just a jury hearing a case, but when someone brings a case. Now, so there's no doubt that you're under parliamentary privilege, and there's no doubt that it's meant to mean that there's no criminal liability. But what about so you either got it or you haven't? And the thing with the Lords is that, in the Lord Hanningfield trial at Southwark, they decided that the privilege was going to apply because the Crown Prosecutor might start going into matters of Parliament. But the thing is, with Roger Hallam was the person who was talking about the campaign, the political cause, which was going into matters that they were addressing Parliament, which that court couldn't decide on. So, really, Roger Hallam, if you go by the basis of Jeremy Johnson KC's paper, 6-page paper on parliamentary privilege, and we know that petitioners get parliamentary privilege without a doubt, Roger Hallam was doing exactly what the prosecutor was not allowed to do in Southwark Crown Court under the Lord Hanningfield case, because it went into the matter that they're taking to Parliament, or the matter that's under Parliament to look at, and it proved that there was a matter for Parliament. The only problem with the Jeremy Johnson paper is that it supposes that the privilege of the peers is repealed in 1967, which it can't have been, because Queen Elizabeth repeals a lot of Magna Carta privileges through the Criminal Law Act 1967, and it's impossible because Parliament opens. This is actually what Thomas Erskine May talks about. Parliament opens with a petition from the Speaker and with the Chancellor that we're opening Parliament and invoking, the wording goes, all of the ancient rights and privileges that have been, right? So, into effect. And they can't open Parliament with all of the ancient right of privileges into use and effect when Queen Elizabeth claims to have repealed half of them in 1967 under the Criminal Law Act. So she hasn't repealed them, and all judgments made against the Great Charter, which includes giving assent to things and making orders in Parliament, says that any judgment or order made against the Great Charter is void. And there's also some other statutes that say that anyone who repeals Great Charter or tries to act against it is a traitor or treasonous to the realm. So they haven't repealed Magna Carta, which means that the peer judgment, Lord Hanningfield had that, and he couldn't have been judged by that jury at Southwark Crown Court anyway. He could have stood. He could have stood trial in front of his peers, which is where he should have stood a trial in front of his own peers. But the basis of the recognition of the privilege is in the criminal procedure rules, overriding objectives, part 1, 2D, and the needs of other cases, HIV. The needs of other cases are the causes, or other investigations that are ongoing, or other civil cases that might interfere with or converge with any other case. But the thing is, they have got a case. The petition case to Parliament is a legal case at the highest jurisdiction in the land, once it's officially declared. You know, so and so you have to go by there's two main parts to it, and that is, you know, were Hallam and these people promoting, you know, Just Stop Oil or Extinction Rebellion under those campaigns which are already declared and people sworn into them, and they're addressing them to Parliament and they're just helping to promote them? And I would probably say yes, right? Now, the final part of it is this. Once you can recognise that a right applies and that they're using the right, okay, which they are, then, you know, like you say, all prosecutions are illegal. And then you might say, well, all of them. Well, what about, you know, if they murder someone, or what happens if they do something that's not for the petition, or not under the umbrella of the petition, or whatever? How can you judge that? Well, this is the thing, right? I wrote a piece called "The Requisitions of Petitioning," which is, you know, what things are usually required for petitioning. Now, the thing is, there are some acts which help us define, and this is the final part now, because I've been going for 36 minutes. Don't really want it to be an hour long, this. This is what I've got in front of me here, because this is why I really started talking about this video, and why I'm going to add this to the petition, even though no one listens. Maybe I can contact Rowan Atkinson. Maybe someone's obstructing my emails so no one receives them. I don't know. But there are acts of law which set out definitions. They set out codified law which is compatible with petitioning, and it acknowledges you're going to be using petitioning and doing it using these acts, and it gives consent. It gives permissions. Even the Criminal Law Act says that you can use a right, privilege, or interest. Well, what is the particular right, and what is a particular privilege? The Criminal Law Act is clear on that. Now, this act here that we've got here is the Town and Country Planning Act, and it covers anything to do with the surfaces of things, which make it so it can't be defacement, right? Sorry, it can't be misconstrued as damage when it's defacement. It is defacement. Anything to do with anything visual to look at it, really, that you place on a surface or put on a surface shall not be regarded as being incorporated into the fabric of the building. So it's regarded as a sign of itself. So it's always regarded as a sign on the surface of it, basically, right? So it gives you the permission that you can use any other enactment in law, of which one of them is the right to petition. This isn't the Bill of Rights, which says that all prosecutions are illegal. It says you can use that act, that enactment. You're allowed to use. You're definitely allowed to use. You're definitely allowed to apply. You're definitely allowed to bring in that immunity, indemnity, in the activities which this act concerns. And this act concerns the activities of placing, positioning signs, banners, advertisements in public. and obviously when you've got it on yourself, on your person, it's a placard, which, you've got the right to do that yourself as a person separately. But now, the thing with this Roger Hallam thing is, in this court case, they were going on about his previous activities, that they'd caused all this hassle or trouble or whatever. But that's a separate case. In this instance, right, they were planning. They didn't actually even do it. They were planning or talking about going somewhere, right, to a road. And as far as I can gather from what I've read in all the reports, I wasn't in that Zoom meeting, so I didn't exactly hear exactly what was said. But as far as I can gather, so what if they were doing training? Training's got nothing to do with anything, really. You can train to put a drawing pin in the wall. You can train to, lift up a brick. If you can train to do anything, right? From what I can gather, they were going to go to a site and they were going to get up onto these gantries or climb up onto them, and they were going to place visual promo for their campaign, right? I don't think, well, this is the question. Were they going to form a line across the middle of the road? Were they going to block the road like that? From what I've heard, they were wanting to climb gantries. If you're climbing gantries, you're not standing in the middle of the road. From what I've heard, what they were planning to do is something like what that Louise did for Just Stop Oil when she was up on the top of the motorway thing, walking up and down, but they were going to put banners up and promo Just Stop Oil. Even, maybe even fasten themselves to it, right? But they're fastening themselves to it as promotion. Now, no matter what you say or do at the end of the day, right, what are the effects of an advertisement or visual advertisement, right? The whole point of the right to petition is that you're not liable criminally for any address to the public, statement to the public, promotion to the public. If you look under the definitions in the 1990 Town and Country Planning Act, that sets out the definitions for what an advertisement is. And this is where we fall under it, or where we're claiming that they fall under it. Even the guy who went to prison for climbing up on the side of that big bridge and putting a big banner up, he was still going up there to install something to make a visual representation, right? It's part of the installation, and you get consent for doing that. You get consent. Well, the council could have gone up and put a big sign or banner there. That's the thing. And I know what you're gonna start bringing in that new Public Order Act 2023 into it. You're going to start bringing that Public Order Act into it and start saying about, interfering with infrastructure, or were they pulling the infrastructure to pieces, were they taking a bridge to bits? No, in most of these instances, they are just getting into a position to install something, or be self-promoting advertisement, which is that they're being either a human advertisement or, And the interference to the infrastructure, look, right, this is the actual fact and truth, right, which is this. Any commercial business or company now can have an advertisement, even a video or film, over the top of a motorway. They've got them on the M621 and on the Bristol motorway, the M32, right? So it's not dangerous or interfering with infrastructure or causing a public nuisance to have promotions, even film, visual, over the top of motorways or highways or beside it. It's not considered dangerous, or none of the commercial companies or brands would be allowed to do it. They got consent. Now, these people don't need consent, right? Now, if just because, you could have you could theoretically have an advertisement, right, which everyone in the motorway just slammed their brakes on or stopped, right? They've got adverts over the top of the M32, right? I mean, it's if an advertiser has a particular advertisement and it causes everyone on the motorway to stop, that the effects of the advert. Now, would the police, say they were planning that the particular graphic was going to cause everyone to be shocked and stopped? Then would they be prosecuted for planning it? Or is that just consequential effect? We didn't know how they were going to react to it. The whole point of a political campaign is to get the public to respond, right? Every advertisement wants you to go buy Coca-Cola or whatever. The thing is that, look at in Japan, in Tokyo, in China, they've got some really weird far out 3D billboard graphics on buildings. Like, it looks like a cat is real, like a real giant cat. It actually looks on the building like there's a real cat actually climbing around on the top of the building. There were videos on YouTube. I've got the video somewhere for it. I screen recorded it on my phone. Can't show you it now. You'll have to just take my word for it. It's like a giant cat, and it's done in a way so that it actually looks like the building is where the billboard is an empty section, and the cat's actually is a real giant cat. Kind of like sort of in a shelf in the building, and actually people were stopping and gasping and all taking photos. People were walking on the pavement and everyone's stopping and taking photos, maybe even walking across the middle of the road and stopping and taking a photo, or maybe someone even in the car has never seen it before, who was on holiday and slowed right down or stopped to look at it, right? People slow down when there's an incident on the motorway, right? They're reacting to an advertisement. That is the sphere and realm of what we're looking at here on this page in law. And you've actually got the political advertisement, any word, letter, sign, a representation, whether illuminated or not, and so forth. That qualifies being on a gantry, even with a colour on. I mean, if you've got a colour outside a polling station, it can be regarded as supporting a certain political party if you're wearing red, right? If it's Labour's colour, it can be regarded as that, So even a person climbing up onto a gantry, not pulling it to pieces or unscrewing it or anything, just climbing up there, wearing a certain colour or Just Stop Oil t-shirt or something, it is, promoting Just Stop Oil. This is to do with, you're getting into art and installation and so forth. And the thing is, just by having a banner up there, a visual sign, if people slow down and stop, that's their reaction, it's open reaction. They might just look at it and learn about Just Stop Oil. It could have been, over the M32 or M621, if you start putting those, they've got digital, they've got animated digital over there, So if they've got a giant cat, what's to say? How can you say people on the motorway aren't going to stop on the motorway to look at it? Or Big Starship Enterprise, I think they had as well. They had a Big Starship Enterprise flying into warp speed. It actually looked like it was flying as well on one of the ones. So what they're doing is the government are approving and allowing all this new technology, which is actually causing the public to stop and interact with it, maybe stop in the road, stop on the pavement or whatever. And it's the public get prosecuted. The public get prosecuted for stopping on the road. They won't prosecute the billboard company. They authorised it and allowed, well, someone could probably challenge it in court, but it's commercial recreation. It's not a political campaign that's protected. If they, in Tokyo, they approve that cat photo, they're all under social points. They'll be giving people social points, for stopping and talking about it. Then if you stop in the middle of the road in a taxi to take a photograph of a huge 3D cat billboard, you are going to get done by the police for stopping in the road. The police officer in Japan or China is not going to If you stop in the middle of the road and get your mobile phone out to film a state-of-the-art billboard with a giant 3D cat that looks real, like out of some kind of horror movie, that police officer in Japan will give you a ticket or charge for stopping in the road. He will not charge, they will not take that company to court. And who's behind that company? BlackRock Vanguard, who owns pretty much everything. You know, they're filling the streets up with these JC Decor billboards, getting in the way of the pavements, you know, cluttering the streets, all for money, profits. They're getting planning approval for it all. No one's questioning whether it's dangerous or not, and etc. They've agreed that these things aren't dangerous, and they're not a distraction to driving to have a particular advert. So it could be, you know, a real Roger Hallam on the motorway gantry holding Just Stop Oil up with a banner securely attached to it, right? It's promoting Just Stop Oil and raising awareness of it. Now, if people want to stop in the middle of the motorway or whatever, then that's their problem. But, you know, stop in the middle of the road in Japan at a big cat to take a photograph, you're going to get prosecuted. So why aren't they prosecuting the people who stop in the motorway if they stop at Just Stop Oil rather than Hallam just, you know, promoting it and then, all right, we know about it now and carry on driving. This is where we are with it. And this is why I've got this act out here, because this tells you exactly. And it's written in a bit of a contradictive way. It's written in a kind of like, it's written to contradict itself, really, because it knows that if you're going to be doing a petition campaign to Parliament, you're going to be using the right to petition and you're going to have parliamentary privilege if you know the law. And there's not really anything they can do to stop that. So it's acknowledging that you can do it and it's in this sphere, but it's got a few little trick clauses. But if you understand it and read it, we can go through them and I can clarify those clauses. So this piece here, this is what the whole thing really comes down to. And they're not even on the page. They haven't even got the book. In that Roger Hallam court proceedings, I don't really know what planet the CPS are on, but they're not even, never mind, they haven't got the book, they're not on the page, they're just not anywhere close to what law is being used and in effect and acted through. The CPS are just literally, I beg your pardon, coming straight in with a prosecution, kind of like a criminal injunction, into an existing case that's not getting acknowledged for the needs of other cases, the legal needs of other cases, and the legal rights and privileges of that apply to other cases, which all have to be recognised, which you don't have to prove beyond reasonable doubt, because no right has to be proved beyond reasonable doubt to a court of law. A right only has to be recognised that it applies. So here we are. And, you know, at 52 minutes now, don't know if Rowan Atkinson is going to get this, because some emails aren't being received that I'm sending at the moment. But I can try to get, I can try attach it to this petition. I can try mail it to multiple accounts of Rowan Atkinson's. So let's go through this. So they're saying that, so there are 5, there are 1, 2, 3, 4, 5. There are 5 points to Schedule 2. And they're saying that number 4, right, it says any structure or hoarding erected or used, it doesn't even have to be just erected, or used principally for the purpose of displaying advertisements, shall be maintained in a condition that does not endanger the public, right? That's the one that you don't have to comply with, but we'll go through all the others in a minute, right? If you don't have to comply with that, and this is where you get all these Extinction Rebellion kind of like bamboo frameworks that they were erecting, all these weird constructions, all these 3D art constructions that people were climbing up and swinging from, that they were getting away with using those for a long time. I don't know if they still do them or not. I don't know if that Public Order Act is because they were putting them blocking McDonald's and so forth, because they're actually a 3D structure that they'd made for advertisement. But actually, they'd only said that they were using it for advertisement because these were just like weird, undefinable structures, right? They were like weird 3D construction art things that they were climbing up on or putting people on and using it for an advert. But it would be difficult for someone to even say that was made for an advert. It was just made as an unidentified object, basically, an unidentified art installation, a structure. It was just a structure. It wasn't. Its purpose really was a structure. The thing is, if you can classify that as for purpose of using adverts or principally, or even, it says any structure or a hoarding erected, well, you erect it when you build it. You erect a church, you erect a building, so that that's all. That's everything. I mean, it's erected, so everything's erect. Every single thing that has been built has been erected, right? Unless it's a flat piece of cardboard or used. It doesn't even have to be erected. It says you can use it for. He says, or used principally. Well, you can choose to use something. You if it's erected for something or used for it. Well, the thing is, motorway bridges are used for displaying signs and words. Because on motorways, it has the speed limit over the gantry, it has speed limits over gantries. There's a guy just been on, I think it was Vobe's channel. He got done because of the motorway signs changing recently. They are actually erected and used for displaying signs, right? So, and the sign is displaying advertisements. So you need to, this is the intelligent part. You need to know when it says here advertisement, what does that even mean? So you go to the 1990 Act, you look up what is the definition of advertisement. It says any word, letter or sign, whether illuminated or not, principally for conveying or representation. So road signs are actually advertising letters, words and numbers to people. And they actually are, those gantries are principally used for displaying information and making representations to the public. So you can't say that those structures aren't actually principally erected for that purpose. It's just that they're mainly used for what signs the government want to have on there, what signs the government want to display on there, right? But as we found with on the M32 and the M6321, they're now having those that are erected for that purpose, or even some that are just a bridge made for cars driving over, they're fitting adverts to that, representations, even commercial ones, even video ones. And who can say what the reaction of the drivers is going to be to that? Or depending on what advert it is, no one can know. Now, if you're wanting to say that, they plan that the effects of this advert are, we hope they're going to do this or that, you don't know that's going to be their reaction. Coca-Cola can say, well, we're strategically planning that, when people see this, they're going to buy Coke, but most people don't, right? They're hoping they do. They're trying to get them to buy. That's the whole point in an advert. You're trying to get someone to do something, but then you're not going to guarantee they do it. When you put Coca-Cola up on there, it doesn't guarantee that everyone's going to go buy it, right? If you put a massive 3D big cat up in China, then you're guaranteed that people are going to stop, get the phone out, take a photo of it, film it. Maybe even people in cars slow down past it if they've never seen it before, or even people stop in the middle of the road and get their phone out and not see traffic coming. So this is where the West, this is where the BlackRock Vanguard, the Larry Finks, the Donald Trumps, the Prince Philip, who's passed away now, the Charles of the world, this is where these big figures behind are actually doing everything that they are saying that you can't do, you're not allowed to do, or it's dangerous. They're actually doing it. And they're getting consent from councils, they're getting consent from governments, Well, having 3D light up adverts over motorways is distracting or dangerous. So how have they got planning permission approval for it when they need permission? It proves that doing that type of thing isn't dangerous or distracting because they've approved it. But when these campaigners go and do the same thing, although a bit more low tech, but it's the same effective principle. It's a visual representation. It's a visual sign, right? It's different, okay, if they're physically stood across the motorway holding a banner like some of them have done. That's different. But in this instance, from what I've heard, they were climbing up at the sides and going to get on top and try hold on or stay on there merely with a physical presence making a promotion. And what the public's response to that would be is you can't say for certain, even if they were intending it to do that. Isn't it a public... Why, when someone puts a gigantic cat in the middle of Tokyo that actually really looks like a real cat from some horror movie like Gone Ginormous, why is that suddenly entertaining even in an immediate urban dangerous environment of Deliveroo, bicycles, mopeds going around cars, HGV, Bjork driving past on the back of a wagon, violently happy or whatever, tourists stopping randomly, people in cars slowing down or stopping. Apparently that's fine. That's perfectly okay. That's not a nuisance. They like, it's a big cat. It's caused a commotion. What they're doing, these big corporate entities, they're trying to legitimize and make lawful and claim it's not dangerous in any way absolutely anything that God can think of, right? But when you do it, you're a criminal, you're a terrorist, or you're wrong. Yeah, it's the exact same law behind it and the exact same principle and dynamic in effect. Further to that, you can't be prosecuted for it. It says that all prosecutions are illegal. You're not liable to criminal... you don't have criminal liability. And you are covered by privilege. And this is the thing that says you can apply Class F, and you can use this is the type of thing you can use that enactment in. It's just that they're stretching their creativity, imagination. That's what they were doing with that big 3D cat, stretching the imagination and doing it over the M32. But they don't like it because the government didn't give them permission. They don't like it because highways didn't give them permission. I think just Stop You, Les, contacted the police to try to get permission from Marble Arch convoy, and the police just said, you don't get permission from us. And they asked the government, they said, you didn't ask us for permission. They couldn't actually even know or find out where they got the permission or consent from because they don't actually need it. It says that there are sections for deemed and express consent which you're exempted from because those sections don't apply to this Class F. Yeah, it says here in these standard conditions, and this is where it catches you out with the wording. It says, no advertisement is to be displayed without the permission of the owner of the site or any other person with an interest in the site entitled to grant permission. Well, they're entitled to grant themselves permission because the consent of the Lord spiritual and temporal in the 1688 Bill of Rights gives consent to use that enactment and protect you from criminal liability. And this act allows you to apply that. It says that you're exempted from both sections of deemed consent and express consent. So you are entitled and granted permission by law, through law, and by use of the right, not from an other individual or government official. because you're opposing the government. The commercial advertisements aren't recognised as opposing the government. They're meant to sell products, although you could say by all the harmful effects of them, they might be opposed to the public because they're taking all their money and making us ill, but that's a different argument for another day. They're commercial, and they have to get their consent from the authorities. Same with, commercial or recreational, right? When it's political, you're actually in a direct opposition to the government. You're opposing them, and in law, you have got equal powers in order to promote anything you need to promote, equal to or depending on how much funding you've got, equal to or to beat the government. But the government aren't really supposed to take sides in these matters or even represent. But they can have a response or a statement. Like in COVID, really, they were giving out advice or so forth, but it's meant to be impartial or whatever, or to their advisors, But, so local councils, when it's Labour controlled or whatever, why? How can you say that the council has Labour control, but then contradict it and say that it's impartial or unbiased? This is like we're getting to the argument of every councillor signs a contract of selflessness, and there's an entire video on that it's impossible to sign a contract of selflessness and then a political party to have control of the council, because they can't, with their own conscience, they can't be affiliated to a party or serve in it. They can't have a whip to a party because that's not being selfless. They're selfless and impartial to each matter that comes before the council based on its evidence, and then what the public objections or responses are, regardless of who voted them in or elected them. You've always only just elected the person. Under that selflessness policy, it's impossible to have political control of the council because it's actually illegal. If the statement that Labour have control of the council actually is illegal, and that is a massive issue that I've recently discovered. Another flaw in the government, just like they repealed Magna Carta when Parliament can't open without it, and then we've even got this Liberty of London in Magna Carta where it's not meant to have any tolls in London, yet Tony Blair put them in. You can't take money for passage through there. So this, let's go back to this first part here. So this, no advertisement should be cited or displayed. So we have got permissions. That part one there of these standard conditions, part one is a little bit of a riddle, because it knows that you're entitled to grant yourself permission through the law. That's the point of using the 1688 Bill of Rights. And if you're using Class F, you're exempted from those two consent ones. So that makes the first part not apply. Because we know this by understanding it. Permission of the owner, well, the public own, right? The public own the public domain, the taxpayer. So it's separate to privately owned. And when you're petitioning the government, you got use of our taxpaid property. And at the end of the day, it's His Majesty's government, and you're petitioning the King, right? And all prosecutions from the King are illegal, or the government. So, you can't be criminally liable for that. So you get the permission, and that's what the police don't like. You get as much permission as someone putting a giant cat 3D thing up in Tokyo and everyone's stopping to look at it, or even in London. 2, no advertisement shall be cited or displayed so as to endanger persons using any highway, railway, waterway, dock, or military. So the argument is then, I don't even think it was argued that it endangered the public or didn't endanger the public. I don't think that it obscured or hindered endangered persons using highway. So just by being on a gantry, right, how are you, you're not necessarily going to endanger anyone just because there's a sign up there and people can see people clinging onto things or on the top of the gantry. Because, they're not even trying to prove whether or not a giant 3D cat is endangering people using a highway in Tokyo, right? So it purely on the response of the people, and even if it did, they're not prosecuting that cat. They're prosecuting the people for stopping. They're prosecuting the people for responding to it. And you're not going to prosecute that cat with that Starship Enterprise one either, because the people behind it who have done it are really the people who are pushing these charges behind the courts in England and behind Parliament. It's the establishment are behind the companies who own BlackRock, Vanguard, those commercial enterprises, and they don't want these people in England here doing these type of advertisement promotions. It's a bit different. It's debatable and arguable when you get into actually standing across the road and physically stopping the traffic. But I'm not. From what I've read, they weren't doing that on this occasion. They were just going up there to put signs up to advertise it, or actually climb up and be on there as a promotion themselves. Which, if you did it safely, and they said they were doing training to make sure that they were safe, but they're not criminally liable either. And this doesn't say that you are criminally liable. Maybe if you said that they weren't allowed to do this back through this wording, you could remove them, but they still can use Class F and that enactment, and that really makes them not criminally liable. Obscure or hinder the ready interpretation of any traffic sign or railway sign or aid to navigation by air or water. Well, that's joke, because there are many of those national speed limit signs on the motorway that aren't working, or the lights are out, and the police know that, and there's lots of newspaper photographs of the police patch across the motorway by those, and no one prosecutes Highways England for obscuring or endangering persons for those being out there, so it's a fault. But in law, in the traffic and highway code, in the legislation and in the statutory instruments and all of I've got all of the highway manuals on a pile, which I've read and studied because I had to do for my own investigation and campaign. It says the legal definition in the manual, which the law says that shall be how the manual says that it is that a sign that is unlawful, which is not prescribed, like an illuminated sign which is got bits of it missing, is in law legally classed as an obstruction in the highway, in law. So that sign that is got digital glitch on it or not in place, that actually you've got an obstruction there. But you're not regarding it as an obstruction. People are just carrying on driving, right? But legally, in terms of law, there is at that point an obstruction in the highway. Now, obstructions in the highway are dangerous, and also it's hindering the interpretation of it, right? And it can endanger people, but no one's prosecuting. Roger Hallam's getting put in prison. Why isn't the person who's in charge of the highway signs getting put in prison or whatever? Oh, he didn't do it on purpose. Well, at the end of the day, it's illegal, and it's just I think those faults have been done on purpose so they can do them, because it's making it look to the public like it's not a big deal, it's not an obstruction, we can do this, and we're not liable for it. Yet, it is an obstruction in the road. So again, what they're doing is they're trying to get away with breaking the law and trying to make it okay because they don't really want road signs to be illegal. They don't want it to be possible. When they put road signs illegally, they don't want them to be acknowledged as illegal and suffer criminal consequences. But we do. Now, the thing is, you might say, well, there's all this government, protection. Have the government got indemnity in their job and so forth, or can they be prosecuted? The thing is, these campaigners are using the right to petition and they've got parliamentary privileges. So, if Highways England have, then they have. And, also Highways are making, there's no intention. The intention is to have signs there that are illegal and attempt to evade accountability for it, particularly when they did plan it. It has been strategically planned. Because all the road signs around England at the enforcement sites have been strategically premeditated and planned illegal. Because I've investigated them all and got the evidence. Hinder the operation of any device used for the purpose of security or surveillance or for measuring the speed of any vehicle. Well, the ULEZ campaigners, protesters in London, have been holding signs up in front of the ULEZ cameras and putting stickers over them and all sorts. And the police chief was on TV and he said that they're allowed to do it. Now, either he knows that this whole section here doesn't really apply to the petitioning right and he's just completely disregarding this bit here, or he doesn't know about this bit here, he's not even read it. So how can the police chief be contradicting this 2C, right? But then he's calling them out on the others. So for the Stop ULEZ campaigns, he's letting them have 2C, but for Just Stop Oil, Roger Hallam, he's not letting them have 2A, right? Or even 1, which is ridiculous. So even the police chief is in contradiction there. And the truth is that, if you're using that Class F with the enactment, 1688 Bill of Rights, you're not liable to criminal prosecution. And then 3, any advertisement displayed and any site used for the display of advertisements shall be maintained in a condition that does not impair the visual amenity of the site. Well, I don't think that those Just Stop Oil banners were or even the odd, these people on the sides, I don't think that they are affecting the visual amenity because you wouldn't even be able to have highway workers on there. And I don't even want to go into training, safety equipment, or the rest. Either the presence of people, right, it is going to hinder the amenity of the site, or it isn't, there are people there with signs up, or there's a big, illuminated sign over the top of the M32. Again, it's we can, you can't. It comes down to that. When we do it, we can do it. It doesn't break all these things, but even though it's the near enough, close, similar, or exact same thing, or close enough, it's highly criminal and a nuisance, and so forth, which is all down to cans and can'ts, who can and who can't, who are you, right, and what authority have you got? Again, same with that cat thing in Tokyo. I've actually done a video on that cat thing in Tokyo. I did a talk on it on my other channel. 3, any advertisement, this is the number, any advertisement displayed, oh no, we've done that one. So number 4 is the one that they'd said doesn't apply. They've said explicitly doesn't apply if you're using Class F and if you're using another enactment. And it might not even have to be the right to petition that you're using. It could be something else. But it says, and this is the one for me that really makes the whole thing ridiculous. It says, any structure or hoarding erected or used principally for the purpose of displaying advertisements. Well, road signs is a class. In the Town and Country Planning Act, you've got class A, B, C, D, E, and F. One of them's road signs, so it's under this act. Shall be maintained in a condition that does not endanger the public, right? So you don't have to, believe it or not, this number 4, ironically, doesn't apply. You don't apply number 4. Number 4 is not applicable. So you don't have to, it doesn't have to be maintained in a condition that does not endanger the public. It doesn't have to be maintained in a condition that does not endanger the public. So that means that if it can't endanger the public, how can it harass the public or even cause nuisance? How can it harass the public or even cause a nuisance if it can't even endanger them? That you don't have to comply with that. So the only argument really is, whether it's next to or near a road or not. But, who's to say whether it endangers the public or not? Because if they fasten a banner on and clip it on or tie it on properly, right, and if they're in position properly themselves, they're just there promoting and advertising something in a little bit of a novel way, that they're trying to make that giant cat look real. They're trying to make the Starship Enterprise look like a real spaceship just flies out and shocks people. Surely, if you've never seen that before, if you'd never, ever, ever seen a 3D Starship Enterprise that looked like a real one, or a giant cat, that actually looked like it was actually real on a building, and you were shocked, what is your first reaction going to be that as a, tourist who's rented a car out, right? You might think the cat's going to jump off the building and slam your brake on and somebody crash into the back of you. That must be equally, it has to be equal to, Roger Hallam on the top of a motorway gantry, who's got high vis on, fastened a sign there securely, even if he's like holding on to it and refusing to come down. How long do the guys up there when they're repairing it go up there and refuse to come down? This is it. They're breaking all their own rules. They're breaking their own rules on the M32. They're breaking their own rules on the M6321. They're saying that, we've authorised it. It's not dangerous. It's not dangerous to do things like that. They've got highways maintenance guys up there, whatever days of the week. That's not dangerous. But when these people do it, and then they've actually even got training to make sure that they're actually going out of the way to try and make sure they're proficient, right? And they've got an immunity saying they're not criminally liable to prosecution, then they're the ones who are getting put in prison. It don't make sense. I wouldn't mind if they didn't have light up movie adverts over the M32 or in London at the side of the motorway. If they said, it's dangerous to do that, it's a distraction, right? Then fair enough. But what they're doing is, if it's commercial and advertising and for money, they like to dare to do it. They're passing it, they're approving it, they're pushing the boundaries, they're stretching the imagination. They are breaking the law. This is like Cameron and Blair. Cameron and Blair have, it seems to be the Prime Minister's prerogative to break the law and get away with it. But they're doing it for the commercial companies now because they like to prove that they can do something and no one else can. But then they're not even official. They're not even government. They're not even using any political rights. They're not even claiming immunity. They've just got a massive suitcase of money on the table, like, £1 million, and they can do whatever they want. Yet they bought it. And then it becomes a norm. No, it's not a distraction. And they're even saying that they're arguing. They don't even have to go to court and defend whether or not the big cat is, a distraction or dangerous. No one's even challenging them. And then if it does cause out in the road, then the public are getting prosecuted. This is what Just Stop Oil and Extinction Rebellion, part of what they're opposing. Robert F. Kennedy Jr., the corporate elite, BlackRock Vanguard, they're in cahoots with the government. They've got more. They've given. They're turning the blind eye, and they're allowing them, really unchallenged, with purely by money, to get away with anything they want because they're rich and powerful, and they're not even using any. They're not claiming any rights, and yet the effects of what they're doing, are causing people's health when they're buying all these products and so forth. And it is a risk of attention and danger. But we're the ones who are getting prosecuted for mobile phones. They're not getting prosecuted for putting light up boards over the motorway. It's wrong, and it's right for people to use similar activities for any cause they want, using rights, particularly even if it's to I think the biggest point here is that if you, it's all about who can and who can't, really, not what is being done and what is not being done. That's what it's about. It's not about what are they doing. It's about who's doing it and who says they've got permission. And who says it's dangerous or not? No court. I don't think any court has said whether a giant cat that looks actually real on the top of a building, who's challenged it? But the police and CPS want to challenge Hallam. Why? There's a question. Why isn't the Attorney General, right, or the Director of Public Prosecutions, or the Prime Minister, Keir Starmer, ex-prosecutor of public prosecution director, right? Why aren't they prosecuting JCDecaux? Why aren't they prosecuting these companies? Oh, they've had approval from the government. Yes, so what? They've had approval. Evidence that he's causing a danger. This is the thing. They're saying, he's causing a danger. It's causing a public nuisance. They're pulling these crimes out that exist, right? And they're saying, oh yeah, we'll have that for this. We'll have this for that. You can prosecute a crime for this or that, or if there's something over a road or highway, you can prosecute, right? But in this instance, no, you can't. I won't mind, but in the commercial instance, they won't prosecute when they can. In the political campaigns group, they can't prosecute, but they are. I mean, what is wrong with these people? In commercial ones, they can prosecute, but they won't because they don't want to, go against their party leaders and their councillors and their MPs, even though that you can prove that it's causing harassment, nuisance or harm. But yet when they can't prosecute, right, remember that sign's commercial. It's not the government sign, it's commercial sign, right? Doesn't matter whether they had consent or not. If somebody has an accident, they can still prosecute that was distracting or caused it. When they can't do it, they're doing it, and they seem to want to do it. It's completely and totally wrong. So it is all under this here, and how you interpret this in the intellectual proper way, where they're kind of being contradictive depending on what enactment you're using, and they know what the effects are, and they've already stated that you don't need consent or express consent. So what is this opening part in verse 1? Because they know that you've got consent from a certain act, because it renders you not liable for what you do, And then number 5, where an advertisement is required under these regulations to be removed, the site shall be left in a condition that does not endanger the public or impair visual amenity. So apparently that is apparently one that applies. Should be left in a condition that does not endanger the public. Yet, right, Apparently, in 4, any structure ordinarily erected or used principally for it, and you can use those gantry signs on motorways because they're under a class for advertisement of a roadway sign, shall be maintained in a condition that does not endanger the public. That doesn't apply. You don't have to maintain it in a position that does not endanger the public. But apparently, when you leave it, you don't have to. You can't leave it in. So that means that when Just Stop Oil go, when they've finished, as long as they don't leave it in a danger, it doesn't matter whether they're causing danger while they're in place, while they're there. They're not liable for causing danger or risk of danger while they're there in place, only after they've gone, if they don't clean it up or tidy it up properly. But I every time I look at this, I keep finding new bits to it, and I'm sure someone's changing it. I'm almost sure that someone's edited this on the internet, some hacker or something. This is the actual opening part of the act. These regulations are the display of advertisements on sites in England only. Parts 2 and 3 of these regulations do not apply to the display of advertisements of a description as set out in column 1 of Schedule 1 to these regulations. So that's the consent. So long as the display complies with the conditions and limitations specified in column 2 of that schedule as applicable to advertisements of that description, and this is it here, look. Except in the case of an advertisement within class F, all the conditions specified in Schedule 2 are complied with. So you don't have to comply with Schedule 2, except in the case of an advertisement within class F. All the conditions specified in Schedule 2 are complied with. And in the case of an advertisement within Class F, the requirements with paragraphs 1 to 3 and 5 of the standard conditions are complied with. Right? So that means not number 4. And number 4 is the one that requires you to not, be at risk of danger, which is ironic, right? And actually, they didn't get prosecuted for causing, putting the public at risk or danger. They only got prosecuted for public nuisance. And ironically, this is the con in this, right? So they've said that you have to apply with, it says requirements of paragraph 1 to 3 and 5 are complied with, but for example, paragraph 1 is about consents and permissions, when here these say that consent and permissions don't apply. So these two, right? These two are removing the requirement of any consent or permission required, which is at the first part of paragraph 1 here. So you've got to understand, right? This has kind of been written, unless you like lay it all out and like I've done, draw a diagram to it. Hold on, I think I've got one. So this is like the index. This is like the first page with the index of the Act, right? And I've drawn this diagram effectively because it exempts you from this part 2 and 3. You don't need these permissions. And effectively, when it says you can use any enactment, right, it means that the provisions of that enactment are going to apply. Now, the provisions of the enactment are that you cannot be prosecuted. That means that you're not criminally liable. Period. That's what the provision of the enactment that you're using. Whether or not any of this act says that, you can't do something, or, maybe it should be, maybe they can move you or move it or whatever, the provision of that particular enactment that you're using does what it says that it does. There's no argument about that. It means you're not criminally liable. And really, this does remove the requirement for any consents or anything. And it's only got some general kind of regulations which aren't really even that, they're not that specific. I won't mind, but they're not even measuring what banners and signs they were putting up. It's more, the CPS would have been more on the right page if they would have been even measuring what they were putting up and what size they were. They're not even checking. There are some specification requirements in here, but really, they kind of aren't. Because you're not criminally liable. So, even though there might be some size regulations, but the CPS don't even venture into that. The CPS don't even acknowledge this act, which is ridiculous. They're just going straight in with a public nuisance charge. They're not like doing what it is that they're doing. The thing is, Extinction Rebellion and Just Stop Oil are actually doing something which uses a law, right, which is this. And they're not even entertaining looking at this act to see if it complies with it and how. Mainly because it allows them to bring in the political rights, and they're going to have to deal with that in a lot more of a clear and clarified way than what the Criminal Law Act allows for the use of a right, privilege or interest. And that's the main reason, I think, because then they start saying, oh, what class is it? And then, oh, using an enactment. And then they have to say, well, which enactment are you using? Whereas, it suggests that it's more clarified than the Criminal Damage Act, which says that, it will not be misconstrued as a defence against a charge if you're using a right, privilege or interest. They don't even want to say, well, what right are you using in that? They don't go there. The CPS just, what's the point having this? And Extinction Rebellion and Just Stop Oil, they're not even going up. They're just going into the court, and I don't know what they're doing, but then they're not doing what needs to be done, basically. To even inform the court of the actual proper thing they're doing for using law.